I'm Mark, and on this channel I talk about UK politics and Brexit from an outside view. Although I do know the UK from the inside as well, so don't worry there. The European Court of Justice, the famous ECJ in Luxembourg, has clarified how the execution of arrest warrants from Great Britain should be handled in the European Union after Brexit. According to the explanations published by the ECJ on a complaint by a man from Ireland who is being prosecuted for terrorism, each arrest warrant from the United Kingdom must be examined separately in the EU member state concerned. The ECJ ruled that the British arrest warrants must be examined for the risk of a violation of the EU Charter of Fundamental Rights for the person affected by the arrest warrant. However, the execution of the arrest warrant may only be refused if there is objective, reliable, precise and duly updated information showing that there is a real risk that a more severe penalty will be imposed than the penalty originally threatened at the time the crime was committed. The execution of arrest warrants is regulated in a separate agreement. The ECJ pointed out that within the EU there is a principle of judicial cooperation based on a high degree of trust, and that a simplified system for the surrender of convicted persons or suspects between EU member states therefore applies. With Great Britain, this principle of trust no longer applies after Brexit. Although such a degree of trust can be established through agreements with third countries, the agreement in force with Great Britain does not, however, establish such privileged relationships. In the present case, a judge in Northern Ireland, which is part of the United Kingdom, had issued 4 arrest warrants against a terrorist suspect. This terrorist suspect argued before the Supreme Court of Ireland that his surrender was incompatible with the principle of legality in relation to crimes and penalties. He complained that Great Britain had changed the rules on early release on conditions following the crimes he was accused of. Due to Brexit, special rules apply to the execution of arrest warrants from Great Britain in the EU. In particular, the executing judicial authorities of the member states must independently examine whether there is a risk of a violation of fundamental rights within the meaning of the Charter of Fundamental Rights I talked about earlier in the event of extradition. The fact that the court dealing with a case in the United Kingdom has ruled out a violation of the ECHR is not sufficient according to the ECJ. The execution of arrest warrants from Great Britain is regulated in the Agreement on Trade and Cooperation, the TCA that you know, between the Union and the United Kingdom. The framework decision on European arrest warrants no longer applies due to Brexit, as I said, and so this Northern Ireland arrest warrant is not an automatic, or what is called automatism for the German authorities, for example, or other EU member authorities. And the Supreme Court of Ireland pointed out that the Supreme Court of the United Kingdom had already ruled that the relevant rules were compatible with the ECHR, as I said. It then also rejected the persons concerned's argument regarding the risk of a violation of the ECHR. However, it was uncertain whether it could also draw this conclusion with the regard to the principle of legality in relation to crimes and penalties enshrined in the Charter of Fundamental Rights. The ECJ answered this in the negative. The executing judicial authority must carry out an independent assessment of this risk in view of the Charter, even if the risk of a violation of the ECHR has already been ruled out. According to the court, when the executing judicial authorities of the member states issue a decision to surrender a person to the United Kingdom on the basis of the ECHR, they are obliged to ensure that the fundamental rights recognized in the Charter are respected. The surrender mechanisms differs from that provided for in the framework decision on European arrest warrants in the TCA. The system for surrendering convicted or suspected persons introduced by the framework decision is a simplified one. It's based on the necessary high level of trust between the member states and the principle of mutual recognition. It is based on the premise that each member state shares with all other member states a set of common values on which the Union is founded and recognizes that the other member states share these values with it. Such a level of trust can also be established through international agreements between the member states and certain third countries, as I said, that have privileged relations with the EU. However, it does not establish such privileged relations between the United Kingdom and the EU in the TCA, and according to the ECJ, that is especially since the United Kingdom is not part of the European area without internal borders. In addition, the TCA surrender mechanism differs considerably in some respects from that regulated in the framework decision on the European arrest warrant. If the person sought invokes the risk of a violation of a fundamental right enshrined in the Charter, the executing judicial authority must examine all relevant information in order to assess the likely situation of that person if he or she is surrendered to the United Kingdom. In contrast to the two-stage examination required for the European arrest warrant, this requires that both the rules and practices generally applicable in that country and in the absence of the principles of mutual trust and mutual recognition, the specifics of the individual situation of that person are taken into account. Brexit has undoubtedly made cooperation between the security authorities between the United Kingdom and the EU more complex, as we could hear. And while attempts have been made to maintain the existing cooperation mechanisms as far as possible, new challenges have indeed arisen. The United Kingdom is no longer automatically a member of EU agencies such as Europol or Eurojust, which are responsible for police and judicial cooperation. The transfer of personal data between British and European authorities has become more complex and requires new legal bases. Conducting joint investigations has become more difficult because the legal bases and procedures in both jurisdictions diverge. And mechanisms for the rapid exchange of information that were established in the EU need to be renegotiated and adapted with third countries. Cooperation in the fight against terrorism is of particular importance. Efforts have indeed been made to maintain existing cooperation mechanisms, but despite these challenges, there are also positive aspects here. The Trade and Cooperation Agreement between the EU and Great Britain includes provisions for police and judicial cooperation. That's why these arrest warrants are possible at all. In many areas, there is still close cooperation between the security authorities on both sides. And flexible mechanisms have been developed to facilitate cooperation in certain cases. The new cooperation involves increased bureaucratic effort, though, and there are still legal gray areas and uncertainties that can make cooperation quite difficult. Political tensions between Great Britain and the EU also had a negative impact on cooperation between security authorities, and we will see how that will change with the new government. But Brexit has undoubtedly changed cooperation between security authorities between Great Britain and the EU, and a new phase of cooperation has begun, characterized by complexity and challenges. And the long-term effects of these changes cannot even yet be foreseen. It remains to be seen how security cooperation between the UK and the EU will develop in the coming years, and after everything the new British government said that they want to improve the relations in this area, we will see how this will develop as well, because at the moment it's all still talk, and we will talk about this again when we have results. And if you want to know more, the next video is right here in the end screen. I'll see you there. I'll be back.